Hi, this is Scott John. This video is about voluntarily paying child support. As you can see from this first slide, don't do this for child support. It's a trap. You voluntarily are paying expenses in lieu of paying the child support you owe. Danger. It's a very dangerous thing, and this video will explain why. First, who we are Atlanta, Georgia child custody attorneys, and I bring this up because, yeah, we do know what we are doing. And one of the most frustrating things we come across is clients being sued for back child support when they say they already paid it. But it's a trap, and don't be one of these people. So, paying for expenses in lieu of paying for child support directly. This usually happens in two different ways. One, you pick up a child's expense directly and then you deduct it from the child support you otherwise pay or would owe the other parent. The second way this happens is you don't pay child support at all because the kids are with you. He or she left the kids with you and went off to do something else. But both circumstances are literally fraught with peril. Proceed with caution. Georgia law on this topic is absolute. No informal agreement between you and the other parent to modify the amount of child support is legally enforceable. This is not a typo. This is not something that the courts are flexible on. Even if you sign an agreement in blood with her, years later, she can come back after you, seek interest, attorney's fees, throw you in jail, suspend your license, have your tax returns intercepted, passport taken, a lot of awful things. The only way child support can be modified so it's enforceable to protect you is by a formal court order. You can really get screwed on this. However, there are two narrow exceptions to this rule, and so let's get to that next. One, she leaves you with the kids, so you stop paying child support. Years later, she comes after you for back child support, but now you're protected. Why? Because you're technically not modifying child support, but instead, when she voluntarily left the kids with you and went off to the military, went off on vacation for a long-term vacation, went to the hospital for an extended period, whatever, college, Kuwait, you have satisfied your support obligation by primarily taking care of these kids. And so even if she comes back and later gets irate and tries to come after you for money, we have a valid defense. The second way is you reach an agreement with her for part or all of your child support money so that you will directly pay some of that money for a child's expense. First, get this in writing to protect yourself. It doesn't have to be a formal writing, an email or a text, something that just evidences your agreement. However, keep in mind that even if you pick up expenses above and beyond the amount you actually owe for child support, you will not get any credit. This only goes against the amount of the child support that you owed, that you paid for the child's expense, and you get no credit above and beyond that. And further, this only goes on for as long as the two of you have an agreement. If she later rescinds the agreement, you're good for what was paid, but stop doing it going forward. So now you're informed and warned. The best thing to do is just pay the child support directly to him or her and don't play around with things. However, things happen in life. For example, if you are given custody of the kids, instead of having to bring a child support modification to reduce your child support, we can defend you on this if you stop paying your child support. But however, this is a dangerous practice, so contact a good attorney who knows what they're doing first before you do it, because there's a lot of nuances and subtleties here. And for example, if you call me with the proper facts, I should be able to tell you yes or no on it. And second, if the two of you agree to use part of your child support for you to pay directly expenses for the children, as long as you have an agreement, and to protect yourself, you want it in writing, again, an email or a text message would be adequate. But you will not get credit against future child support payments or past arrears for money you pay above and beyond your monthly obligation. Know these rules, follow them. There are nuances here that I'm not communicating in this video because they're difficult to communicate. You just know them when you see them. So talk to a very good attorney who has expertise in this field, and all will be well. So I'm Scott Shaw, I'm founder of the Shaw Law Firm. We'd be happy to talk with you. Divorce and child custody cases are all we do. We've been doing this since 1995. And yeah, sometimes getting a fair shake in court takes a fight. This is what we do. Thank you.